Good morning. Our next case is Merrell et al. Versus Smith et al., and we will hear from the appellant.
Mr. Chief Justice and Associate Justices, my name is Matt Learberg, and with my co-counsel Aaron Hemmings, we represent the plaintiffs in these consolidated cases. I'd like to reserve 5 minutes for rebuttal, please. The key facts here are not disputed. Mike Smith knowingly shared inside information with his business partner and longtime friend at a time when that person, Rick Siskey, was not even a member of the company. Siskey then used that inside information to buy the plaintiff's shares at a steep discount. And the central question in this appeal is this: can investors in North Carolina companies trust that such insider trading will remain unlawful and that they can seek redress in the courts? The decision of the business court below should be reversed, and this case should be allowed to go to a jury to decide which of these claims survive to give relief to these plaintiffs. Now, the business court got off track right out of the gate in its analysis of the fiduciary duties that apply in the LLC context, and I'd like to start there. In a series of cases over the last few years, the business court has referred to it as the law as being unsettled, and different business court justices have wrestled with what fiduciary duties are owed by those in an LLC. And it cries out for this court to provide that clarity to the business court and to the businesses that operate in North Carolina. Fortunately, to some extent, this has already been decided, and it's been decided for 80 years. As far back as 1951 in the Gaines case, this court held that, at least in the corporation context, that majority shareholders have the power to do everything that the corporation can do, and in that sense, they're trustees for the holders of the minority of the stock. As a result of that, the fact of control, so it's a fact analysis, the fact of control of the common property held and exercised, and not the particular means by which the control is exercised, that creates the fiduciary obligation on the part of the majority stockholders in a corporation for the minority holders. There is no reason why this court should construct a new rule in the LLC context.
But isn't the existence of an operating agreement in the LLC context that gives, especially the one that was in place earlier in this case, that gives all of the stakeholders a vote in some really important control context, isn't that an important distinguishing factor from the corporation's cases?
It absolutely is, Justice Riggs, and the way that it fits in is to this question of control. So for a corporation, control's automatic, right? There is no way to disclaim those fiduciary duties. In the LLC context, there are ways, right? It's a matter of contract, and especially after the 2013 amendments to the statute, but even to some extent before, the question of parties being able to contract around some of those obligations, I mean, that's absolutely part of what is now 57D. But the question is then, it becomes an examination of what the contract says. So the default position is, it's just like in Inc. Anyone who's a majority shareholder, anyone who has control of the company, those folks are going to owe a fiduciary duty to the minority shareholders, just as they would in a corporation. In the LLC context, there are ways that contract might be able to change those default rules. And the central question here is, did that happen? And an examination of the business court cases that have wrestled with this over the past few years provides a wonderful foil for the operating agreement here. The word fiduciary appears one time in the operating agreement, and it appears in the part of the operating agreement to reference that there is a fiduciary obligation. In the documentary exhibit page 36, in an exhibit to the operating agreement, every version that's relevant here, says that new allocations made by the manager under this section shall be deemed to be made pursuant to the fiduciary obligation of the managers to the interest holders. Manager, that's Mike Smith. Interest holders, that's the plaintiffs. So if it does boil down to a matter of contract to change the default rules, then we look at the contract and we see that the one mentioned of fiduciary obligation is a positive one. All that Mr. Smith had to do when he had control of the company was to construct a different operating agreement. I mean, the premise of kind of the contract of the operating agreement being at the core for LLC duties, it's this kind of fiction that everybody sits around the table and negotiates it. Well, Mike Smith could have negotiated with himself when he wrote the operating agreement, or at any time he amended it, to address this issue of fiduciary duties, but he didn't. It remained silent on fiduciary duties other than this one place where it positively mentions fiduciary obligations. So for that reason, to the extent that LLCs are to be treated differently because of this contractual duty, there's nothing in this record to show that this operating agreement disclaimed those. But it goes beyond just the operating agreement. I mean, what the Gaines court said, this court in Gaines, is that control is a factual question. And the business court cases below, Vanguard, et cetera, have wrestled with, what does it take for those facts to show control? Well, in this case, we have Mike Smith running the company, right? At one point, he sends out letters on October 1st, 2007. He sends these letters to all of the investors, disclosing some, but not all information. And he sends them by certified mail, gets the green cards back, and he and Jennifer Smith keep those green cards in their attic.
And Mr. Lehrberg, if I might interrupt you at this point, because I would like to explore the issue of those emails. I believe your friends on the other side have actually, I will quote it, that they have acknowledged that it is a well-established that once a party chooses to speak, that party has a duty to make a full and fair disclosure of facts concerning the matters on which to which he speaks or chooses to speak. And you mentioned that there has been this email. What is your position with respect to that email and this particular? I believe it's from the Aldridge case from the North Carolina Business Court, but I think it's a fairly well settled law across the country as far as that statement. What is your position vis-a-vis your case?
Right. The duty to speak, as well as once someone assumes the duty to speak by providing some information, that is well-established law, and that is part of what Mike Smith did wrong. All he had to do was keep his mouth shut, just like lawyers and judges do. Confidentiality is part of big jobs.
But once he has spoken, what I'm grappling with is at what point, where is that line when once he did speak, perhaps I think the argument is that he was trying to correct the fact that he had spoken, or at least even things up. Those are my words, certainly nothing in a brief. Where is that line when there is enough or too much that should have been said? You're right about once you speak, with the confidentiality, I understand that, but I'm really getting to those emails and whether that was enough and whether that was full and fair disclosure, that sort of thing.
Right. So let's walk through the timeline. In December of 2006, Mike Smith sends an email to Rick Siskey and discloses something that he never discloses to the plaintiffs, ever. And that is that the new CapCan deal is going to generate $6 to $7 million in annual profit. Now note, this is at a time when the profits of the company are hovering around $2 million. So this is kind of a 4 times multiplier. Highly material information. It would be hard to dispute that that's material. He shares that with Mr. Siskey in December 2006, and then at the annual meeting, and including an email that comes up in March of 2007, or letter, there's no disclosure of that fact. That fact is not disclosed.
Well, and if I might follow up, that was only a prediction, though. And I realize he did make that disclosure to this other individual, Mr. Siskey, but that's only a prediction, and the question in my mind is, could he have caused more trouble by sharing that, since it was only a prediction and there were no contracts? It was more of a hope or whatever, as opposed to a definite that this is going to happen. What's your position on that?
By March 2007, my understanding is that deal had already closed. That contract was in place. So the revenue projection and the profit projection of $6 to $7 million was not speculative. It was a fact at that point that should have been shared. And the inside information continues on into the fall. It gets so bad. I mean, the evidence here, probably the number one piece of evidence.
Interrupt real quick, because just to
Justice
clarify, so we're not talking, these are not facts anymore they're talking about that create a fiduciary duty. We've moved on to talk about whether, these are facts about a breach of a fiduciary duty that exists, right? None of these things the fiduciary duty would have to exist based on something else, not the fact that you were disclosing information. Those are breach questions.
That's my understanding of where Justice Berenger is going.
Right, I
with
just
this
wanted to be
question.
clear, so we've kind of moved analytically to the next part of the business court's analysis.
I think that's right, although, I mean, the decision to speak, right, in a position like this is also a way that a fiduciary duty can be created in fact, right? So there's de jure fiduciary duties, and then a fiduciary duty being created in fact by that decision to start disclosing information. And as we move through 2007, it gets so bad that Mike Smith summons his lawyer, Gary Smith, one of 2 times that he summoned him in the history of the company, and said, we need to send a letter that has, because I have been sharing inside information. I mean, there's no need to speculate whether inside information was shared because Mike Smith admitted it. That's why there's a letter on the record that says so. And that letter says, critically, it not only says to Rick Siskey, you know, we understand you have inside information, you can't use it to anyone's detriment. The last paragraph says that I have advised Mike Smith not to approve any transfers until adequate, you know, until the field has been leveled, the information playing field. This asymmetry has been corrected. All that Mike Smith had to do, he had several off-ramps throughout this case. He could have sent that letter to the plaintiffs so that the plaintiffs knew that this person coming and telling them, hey, I'd like to buy back your shares, that that person had inside information. All he had to do was share that letter, right, the October 2007 letter. But he didn't. And after Gary Smith wrote that letter, Mike Smith himself, without his attorney's help, wrote a disclosure letter saying we might put the company on the market for sale. That letter, the October 1st, 2007 letter from Mike Smith to the plaintiffs and other investors, is a far cry from the type of information he was sharing with Rick Siskey. It's the classic mixed bag, right? We have some potential, but we're gonna incur new debt. We're partnering with Rexam on CapCan, but we're gonna have to build out the facility. And let me be clear, there's nothing wrong with a letter like that, to get to Justice Berenger's question, right? By itself, right? In a normal case, in a normal situation, business leaders are cautious. You don't want to come out and make promises that you can't keep. The problem here is the asymmetry. It's the asymmetry between what was shared with Rick Siskey over the years, and the evidence we have is just the tip of the iceberg there, and what was shared with the plaintiffs. And Mike Smith had one last chance to get this right. When those consent forms came before his desk, he could have followed his own attorney's advice. What his attorney said is, don't approve transfers until you're sure that there's a level playing field. But he didn't. He signed them. He signed every single one of them for the plaintiffs. And he consented to the transfer of shares to Rick Siskey, his close friend, his confidant, the first person he emails when he gets good news in business, with a new deal. And that continues all through 07, 08, 09, throughout the whole record. Mike Smith knew that he was sharing that inside information.
And if I might, before you move on to that, the fact that he did sign those, there's certainly arguments that because there were the consent documents by the other members, at least in the early part of this, that was appropriate for him to move forward after he did make those disclosures, and then he did receive the consent forms from the other members to actually transfer the shares. What's your position on that?
I want to make sure that I understand the question. I mean, there are 2 batches here, right? There's a batch before the 2007 amendments to the operating agreement. And for those batches, there were a couple other signatures that were needed.
Right.
Afterwards, Mike Smith could do it himself, Mike Smith and Rick Siskey.
Right, and I'm asking with respect, at least with respect to the prior, when he needed the other consents.
Right. At that time, though, to be clear, it was not 100% consent of the members that was needed. None of the plaintiffs knew that was happening. And Rick Siskey, he chose his victims wisely. They didn't know each other. None of them knew that Rick Siskey was amassing these shares from others as well. They thought they were the only one. But the person who did know is Mike Smith. Mike Smith knew. He knew that his best friend here was accumulating a massive stake in the company. And nobody else knew, right? I mean, Jennifer Smith knew she was part of this, but years later, right, when the company sold, John Stritch's daughter, who was a senior vice president, she was shocked to see that Rick Siskey had this significant stake in the company. Mike Smith knew enough and was part of this arrangement. He changed the operating agreement multiple times for his friend. I mean, in 2003, I know that's a few years before, but in some ways, this one's quite telling, right? In 2003, Rick Siskey had just encouraged all of the plaintiffs to purchase shares and to provide that seed capital to get the business off the ground, $2.7 million. That was something that a big favor that he had done for Mike Smith, kind of an interest-free loan. And in compensation for that, he was given these cheap shares, right? $10,000 instead of $100,000 a share. Rick Siskey wanted to sell those and make that $90,000 profit. And Mike Smith knew that that would look bad, and he helped his friend, right? He changed the operating agreement so that they could be resold quietly without all of the plaintiffs knowing that the very person their very fiduciary who had just sold them the shares was now selling his own shares.
So, Mr. Learberg, to Justice Dietz' point, I think I got us off on a tangent when I asked my question right out of the gate. I think it might be a good thing to double back and talk about fiduciary obligations. Sure. As I said, I'm the one that got us off track. And perhaps I can do this with the start of another question. You cite in your brief United States versus O'Hagan for the proposition supporting that North Carolina, and I realize you have the Gaines case in there as well, but that North Carolina should or does have an obligation, fiduciary obligation for in this LLC context. I'm struggling with the fact that I don't see how the United States versus O'Hagan, other than stating some information generally about fiduciary obligations of officers and directors in a corporation, has, and even that is analogous argument, certainly not on point. But that particular case is a Securities and Exchange Commission 10B and SEC Rule 10b-5 case where Justice Ginsburg makes it clear in the law that the misappropriation theory under securities reg would, we don't just have to be stuck with the traditional theory. I don't see how this case is particularly relevant, and I'd like to know why you cite it in your brief.
That's fair. And, the reason that we cited really any of the federal cases, including that, is because, this court has held that our Securities Act is modeled on some of the federal securities laws, and so the federal cases are instructive. That's all. It's not controlling in any way, and if I gave that impression, I apologize for that.
Well, and certainly, as I said, I know Justice Dietz did ask the question earlier, so it might behoove us to hear a little more about the fiduciary obligation situation in North Carolina.
Sure. So Gaines sets the table for corporations. This court has not pronounced, and I don't want to leave any misimpression here, this court has not ruled on how these fiduciary obligations apply in the LLC context. That's why the business court finds it unsettled and is scrambling to some extent to understand how this works. But the principles from Gaines, the principles that are applied in many states, including Delaware, is, yes, these fiduciary obligations, in the same way that they arise in the common law context for corporations, they arise in LLCs to the extent there's control. And that brings in Justice Riggs's question. Why are LLCs different? They are different. They're different because the parties could sit down and negotiate those away, right? They could write into the operating agreement clear as a bell that, as we put in our brief, the managers have the right to share selective information. They have the right to share some information with some members and not with others. I mean, it would be odd to see that in an operating agreement. Usually they would just say, we disclaim all fiduciary duties. This operating agreement doesn't say that. I mean, this case.
Let me ask you, I'm curious about the scope of the duties. So suppose the disclosures, what you call the insider trading, the discussion with Siskey, that never happened. If Smith had provided the information in the October 1st letter, just like happened in this case, and then the sale went through, was there any breach of fiduciary duty?
The October 1st letter.
The disclosure that he provided about the sale,
no.
Would that have satisfied his fiduciary duties in isolation?
Yes. And I want to be clear about it.
So, well, that's what I'm getting at. So what about disclosing more information to Siskey would have altered the duty of disclosure that Smith had just in isolation? Why does that change?
It changes because a majority shareholder who has all of this control and knowledge the minority shareholders are trusting him, right? Just as they are in a corporation context, they are placing their trust in him as a matter of law and as a matter of
That's what I was
fact.
wondering, is suppose Smith knew that Siskey was gonna cheat the plaintiffs through some other insider trading scheme that had nothing to do with the company. Would he have a duty to tell them that Siskey was about to do that?
No, right? Because you're a fiduciary as to something particular.
Well, and that's what I'm getting at, is that what is that thing? What, in this case, what is the duty? Because if the disclosures that he provided, just standing alone would have been enough to satisfy the fiduciary duty. If he doesn't have a duty to alert them that someone else is about to cheat them, how do we combine those two together and somehow get to? But in this case, he did have the duty.
The reason he knew that Siskey was about to cheat them is because of information that he provided to Siskey. I mean, the nexus is there. It couldn't be a closer nexus. The only way that Siskey is able to pursue this scheme is because of the information that Mike Smith and Jennifer Smith share with him repeatedly over the years. And that information asymmetry goes to the fiduciary obligation. I mean, a majority shareholder, just like in a corporation, right? A majority shareholder couldn't, provide an inside tip to one shareholder and not another. Why is that illegal, right? It's illegal because of that informational asymmetry at a time when minority shareholders are trusting you. Right? They are trusting Mike Smith to treat them fairly. That is the duty that he breaches here. And I mean, I think a key fact here is several of these plaintiffs, right, they had an IRA custodian that handled this investment. And Mike Smith was obligated every year to make a representation to that IRA custodian as to how much he thought the stock was worth. So at the same time, he's telling Rick Siskey this inside information, 6 to 7 million on CapCan. Who knows what other things he's telling him that gets Siskey with dollar signs in his eyes chasing these shares. At the same time he does that, Mike Smith represents that the shares are worth $150,000. That's inconsistent. He's telling Siskey, for example, in the tax documents that we see from 2008, that this is going to be an $80 to $150 million sale. And he's telling our clients that each share is worth $150,000.
At the time he made that representation, though, was it inaccurate at that time? I mean, I know there was this promise of a future deal, but I could see a difference between, saying this is the value of the share right now. I understand it's, I believe it might be more in the future, but did he misrepresent the actual value of the share at the time?
Well, I don't know that there needs to be an official valuation as to what the share was at that time. The relevant fact is that he's making wildly inconsistent representations. The shares ultimately sold at a value of $1.7 million. So he's telling Rick Siskey, as we know from these tax documents in November 2018, he's telling him, essentially, the share value is $1.7 million, and he's telling our clients it's $150,000. So whichever is right, in some respects, it doesn't matter which is right. What matters is that he's providing these wildly inconsistent valuations to two different shareholders.
What's the year difference between the valuation that you're talking about and the sale?
The sale is in 2010. So we're starting at December 2006 with the 6 to 7 million. The plaintiffs sell their shares back with Mike Smith's consent in late 2007 and early 2008. The tax documents show that the prediction was that 9 to 18 months would be the timescale for a sale, and that turned out to be roughly correct.
So if a person in Mike Smith's position were to tell minority holders, oh, by the way, boy, we're going to sell this and it's going to be great. Hang on. Don't sell to anyone. And then none of it comes through. And you've got the increased debt that he has forecasted. We would be here just in a different way with the plaintiffs suing the defendant, saying, oh, you told us this was going to happen, and it didn't.
The key difference is this. Investors assume risk, right? They do. They assume risk. They assume risk that projections will pan out or that they won't, that the debts will lead to revenue or they won't. But what no investor assumes is the risk that their fiduciary, the person running the company, is going to defraud them. That's not a risk you assume as an investor. So yes, the kinds of market forces that could have changed things Absolutely, Your Honor. Those are things that folks are stuck with. You're stuck with those. You hold your stock out of a hope and a prayer that things will work out. Too bad, right? But no investor, especially a minority investor, assumes the risk that they're going to be defrauded by their investment advisor, who's a fiduciary, working closely with the majority shareholder, the majority interest holder and managing member of the company. That's the difference. And that does touch on the Securities Act claim that I'd like to address briefly.
Before you go to that, if we were to agree that there was a fiduciary duty, in looking at the scope of it, what impact should the operating agreement's provisions giving members the right to request business and financial information have on our analysis?
Right, and Your Honor, you're correct that if this case turned on, Mike Smith representing things that you could find on a balance sheet and sharing that information with someone at the same time he's not sharing it with the plaintiffs, then yes, the part of the operating agreement that allows access to the books and records would be relevant as a diligence matter. But there was no way for the plaintiffs to know the things that Mike Smith was sharing with Rick Siskey. The books and records would not have revealed his calculations as to the valuation. That $80 to $150 million figure, that doesn't appear. The 9 to 18 month time span, that doesn't appear. The mention of Red Bull as early as 2008 as a possible deal, that's not something that appears in the book. So even with the evidence we have, and we're lucky to have this evidence as the tip of the iceberg of what was shared, even with the evidence we have, we can see several facts that are shared with Rick Siskey that are never shared with the plaintiffs. And so that provision of the operating agreement really doesn't undercut that at all. And I do want to address briefly the Securities Act claim. The Securities Act claim was thrown out by the business court on one ground, and that is the statute of limitations. But to be clear, there's a tolling provision that was inserted in the 2003 amendments. The General Assembly saw fit to strengthen our Securities Act in North Carolina. And the exception is that if a person who may be liable under the act engages in any fraud or deceitful act that conceals the violation, then the discovery rule applies, right? The claim doesn't accrue until later. It doesn't matter how long it takes, as this court held in Forbes v. Neal. Sometimes the discovery happens quickly, and sometimes it doesn't. Here, the plaintiffs were fortunate to discover this later. The sale of CBB was not public. The amount of the sale was not public. There was no information out there that our clients could have discovered over time until Mr. Siskey died and his treasure trove of documents and his emails that he had printed out came to light. If there are no more questions at this time, I'll reserve the balance of our time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
May it please the court, Mr. Chief Justice and the Associate Justices. My name is Mike Adams, and with my colleagues Nicholas Lee and Coker Holmes, we represent Mike and Jennifer Smith, who are seated behind me in the gallery. Judge Robinson's decision is completely consistent with established North Carolina law and the record in this case. His opinion was both thorough and correct. Plaintiffs did not present substantial evidence necessary to avoid summary judgment. While this case is the Smiths' personal nightmare, has been going on for 5 years, it would be any entrepreneur's nightmare. Plaintiffs all made between a 25% profit in 4 years and a 250% profit in 7 years. The undisputed evidence is that they have no damages. Most sold for fair market value or more, and we have unrebutted evidence of the fair market value of the stock at all relevant times from our expert. What Mike Smith and John Stritch did, building the business in this state, we want to encourage. What these plaintiffs are doing, coming before this court with innuendo and no facts, we want to discourage by all means. The entrepreneurs, Mike Smith and John Stritch, employed outside counsel who supervised every aspect of every transaction in this case, from the drafting of the private placement memorandums and the onboarding documents, to the letter to Rick Siskey, to the sale agreements that these plaintiffs sold their shares to Rick Siskey. There is no evidence in this case that Mike Smith ever received anything more than his 52% interest in CBB, or that he had any agreements with Rick Siskey. Mike Smith's 52% produced a huge return, as did the other 48%, which was distributed to the other 42 members at the time. Mike Smith did not make any more money because of these plaintiff sales. He never purchased any shares. 11 and a half years after they sold their shares, Mike Smith, as the majority owner, is being sued because he consented. That's what he did. He consented. The entire basis of this action is an attempted guilt by association, because it turns out Mr. Siskey may not have been a wonderful person. The plaintiffs contend that Mike Smith withheld information, but Judge Robinson correctly found that there was no substantial evidence of that Mike Smith withheld any material fact, and certainly nothing about the pleaded omissions, which were Red Bull negotiations, a pending sale of CBB, and that Siskey was purchasing membership interest. Judge Robinson also correctly found that there was no record evidence showing that Mike Smith had any intent to deceive, or that any plaintiff reasonably relied on any omitted fact. It is undisputed that CBB notified every plaintiff in writing by the October 1st, 2007 letter that CBB's profits and revenues were exploding and the company was going to explore putting itself up for sale. These plaintiffs had access to every shred of CBB information and never requested any of it. They conducted no diligence at all. I'll address the alleged evidence that has been presented, but it does not meet the substantial evidence standards that this court has consistently announced. The earliest case we cited was Lane versus Bryan, but this court made decisions on that in the last round of opinions in Beavers versus McMiken. And Jennifer Smith is in this case for one reason and one reason only, and it's very obnoxious. She happens to be Mike's wife. She was a contract employee. There is no basis to hold her as a fiduciary. No plaintiff ever reposed any special confidence, and she did not dominate and control anything related to these transactions. In this case, the Supreme Court is called on to evaluate the duties of a majority member of an LLC when consenting to membership interest sale transactions between two minority members when both represent in writing they've had a reasonable opportunity to review the books and records of the company. The undisputed facts show that plaintiffs decided to sell their membership interest without even consulting Mike Smith. There was another method available for them to sell their shares that would have resulted in an appraisal process. That's in Article 7 of the operating agreement. But plaintiffs didn't choose that process, even though it had been described in the 2003 letter with the amendment, and it had been used once before, as we showed in the record. According to the Court of Appeals decision in Sullivan versus Mebane Packaging Group, you cannot rely on statements of value if you have an appraisal process available to you. Not only did these plaintiffs intentionally forego their right to have their shares appraised when they were sold, they never even most never even negotiated the price with Siskey.
Well, and sir, if I might interrupt at this point, Mr. Adams, I'd like to ask you the same question that I asked your friend on the other side. Certainly the argument you're making is apparently factually correct, but one of the facts that you're omitting is the fact that there was a tip, or at least information shared between your clients and Mr. Siskey, the late Mr. Siskey. And as I stated earlier, you did acknowledge in your brief that it is well established that once a party chooses to speak, that party has the duty to make a full and fair disclosure of facts concerning the matters on which he chooses to speak. Quoting, I believe that's one of our business court cases, but it is a fairly standard, I think it's a well-accepted legal principle in this area. What is your position on that based on the disclosures that did go to the shareholders after that information had been shared?
Our position on that point, Justice Behringer, is that the October 1st letter cured any alleged information disadvantage. Keep in mind, the alleged tip was not a tip. Siskey was entitled to this information at the time, and a December 2006 email saying that someone is going to approach us is vastly different than when Mike Smith made the decision to put the company up for sale. And the cases draw that distinction. There is no duty of disclosure just because someone approaches the company. The duty of disclosure arises only when the company decides to pursue actual sale plans. And Mike Smith went to company counsel, and company counsel counseled him as to what to do. So the October 1st letter cured anything about an information disadvantage. And Your Honor, the proposition, once you speak, you must speak fully, that relates to vendors and purchasers, and Mike Smith was not a vendor or purchaser. The Ragsdale proposition does not apply to Mike Smith.
So suppose,
One more follow-up. I think I heard you say that there was not a tip in this case. Is that your position?
That's my position.
Can you explain why?
Because all members were entitled to all information of the company at all time. And any information that Mike Smith provided to Rick Siskey was lawful. It was pursuant to the operating agreement. But moreover, there is nothing material about the information that was provided to Rick Siskey. Word on the street is a rumor. The CapCan contract was signed the day before the March 29th, 2007 meeting, and we have Mike Smith's notes of what he recounted to the shareholders at the March 29th, 2007 meeting, and he gave them a full and detailed discussion of CapCan and its impact on the shareholders.
Well, sir, if it wasn't a tip, why was the council so concerned that they sent a letter saying that this may have been a violation, or it is a violation, of the Securities and Exchange Act, and as a result, counseled your client not to approve any future distributions, or, well, it would be a distribution, but any future sales?
I believe the record shows that Mike Smith had met with Wachovia, and Rick Siskey knew that Mike Smith had a meeting with Wachovia. And this was counsel's advice to do that. Counsel's letter does not say that Rick Siskey is engaged in insider trading. He says, you must disclose all relevant facts to these purchasers. And so the company counsel's letter to Rick Siskey is perfectly appropriate. And moreover, that's a decision of counsel. The safe harbor of 57C 3-22D protects Mike Smith in that circumstance. Mike was acting as a manager. He approaches company counsel, which is exactly what we want managers to do, and he followed company counsel's advice. That shields him from liability. He did not withhold information about plans to sell the company, and he did not withhold any financial information. The disclosures in this case, there's a reason I put them in chronological order in our appendix. We put the disclosures in this case so that the court could see how robust this company informed their shareholders. There is some basic propositions that I think can resolve this case. One I referred to, 57C 3-22D, the safe harbor, which applies to managers. Second, exercising a contractual right to grant or withhold consent, this court in Corwin held does not implicate a fiduciary duty. And third, for all the misrepresentation-based claims, reasonable reliance must be shown by actual evidence. That's the holding of Dallaire and Arneson. I'd like to...
One question I had was, suppose the day after Smith talked to Siskey, so at the end of 2006, under the operating agreement, could other members, if they had gone and said, I want to, as is my right in the operating agreement, get some information about the company, could they have found out in any way about, the Red Bull possibility, any of the things that he told Siskey? Yep. Was the operating agreement allow you to do that? Because I think your friend argued it's really just getting financial information. You're not going to get, any sorts of things that were in that conversation. What's your position?
The operating agreement has information provisions in it which are multiple, but they work this way. You can inspect all books and records of the company. You can also ask the company questions, and the company is obligated to provide that information to you. So that information, if it was there, because there were no Red Bull negotiations, so there would have been nothing there. There's no substantial evidence that there are any Red Bull negotiations until a year after these plaintiffs sold their shares. So it depends on what information is in the company's records, but yes, any information about the company was available to any of these shareholders at all times, and anybody had a right to come in and inspect anything at all times, and there was never a duty that says the company must affirmatively inform all other members of what that member has inspected. There's always a possibility that one member would have more information than another. That is just how this operating agreement works, and that was the agreement. There's no evidence in this case that any of... Yes.
Counsel, I'm sorry, your position is essentially a minority shareholder has an affirmative duty to look after their investment.
They have some obligation of reasonable diligence at all times. Yes, Your Honor. There's no evidence in this case on the fiduciary duty point that any of these plaintiffs reposed any special confidence in Mike Smith. They never spoke with or relied on him in any way. The undisputed evidence is that all of these plaintiffs relied on Siskey, and that from the Watts versus Cumberland County Hospital System case, that means Mike Smith does not have a fiduciary relationship. We've talked about, I think it's important to distinguish between Mike Smith's conduct as a manager and Mike Smith's conduct as a member. I've referred to the safe harbor, which applies to Mike Smith's conduct as a manager, but manager duties are owed to the company. That's the holding of the Kaplan case. And there was no derivative demand nor derivative claims asserted in this case. The plaintiffs cannot pursue manager-based duty claims. Moreover, on page 39 of their brief, the plaintiffs admit that everything that Mike Smith did was not ultra vires, meaning he acted fully in accordance with the operating agreement. As a member, the only thing that Mike Smith did was consent. That's how he used his voting power. As the court is well aware, his consent was not sufficient for approximately half of the sales because 65% was required, and for the other half of the sales, Mike Smith's consent was fine. But consenting constitutes the exercise of a contractual right, and as stated by the court in Corwin, that's not acting to protect the plaintiffs, that's acting to protect the consenter's own property rights, and therefore it does not implicate a fiduciary duty. The assignment and purchase agreement that each seller signed stated that they had a reasonable opportunity to inspect the books. That's section 5D in our appendix at page 210. That's what Mike consented to. He consented to a sale where the plaintiffs represented they had everything they need. At that point in time, he had no further obligations. The scope of the majority owner's duty, which was announced in the Gaines versus Long opinion in the Chapter 55 corporation context, is to put the invested funds to good use and to pay the investors their percentage interest. Mike Smith and John Stritch did that. As we pointed out in our brief, we can't impose a fiduciary relationship on the majority shareholder to choose which of the minority shareholders he's going to favor in a transaction. You can't have a majority shareholder have a fiduciary duty in a transaction between two minority members because it would require to choose between two people to whom he owed an equal duty. I'd like to move on to the fraud arguments. There are 4 separate reasons that Judge Robinson dismissed the fraud claims, all of which were about no evidence of a fault of an omission, no evidence of a material fact, no evidence of intent to deceive, and no evidence of reasonable diligence. The plaintiffs did not submit any affidavits. Rule 56 is clear. You must present the court with specific facts showing there's a genuine issue for trial. From Value Health through Beavers and Lane versus Bryant, the rules of this court are if the evidence amounts to just a conjecture, if it's just a guess who ran over the plaintiff, it does not go to the jury. And none of the evidence that the plaintiffs have provided moves beyond conjecture that Mike Smith did anything wrong. Rule 9B requires all fraud claims to be pleaded with particularity. The only fraud claims that were pleaded in this case were about the non-disclosure of a pending sale, which did not exist, the non-disclosure of Red Bull negotiations, which did not exist, or that Siskey was purchasing shares, information that was always available to these plaintiffs at all times. In referring to the items of evidence that were referred to, there is a reference that amendments to the operating agreement were somehow done with a fraudulent purpose. These were prepared by counsel and voted on by all members. All members voted to change percentage approval requirements. They did not have to do that. They voted in favor of those changes. The December 6th email I've already spoken about, but the case I was trying to remember was Sullivan versus Mebane Packaging Group. That case makes clear there is no duty of disclosure until there's an actual plan of sale. We don't want to avalanche investors with a play-by-play of everything that the company does, because that's not useful at all. There was reference to certain emails of an investor, Scott Jernigan, which use these vague terms like the mother lode. We're now starting to move on CBB, tiny circle. We're supposed to draw by conjecture that that information came from Mike Smith. He's not involved in any of those emails. It's just sheer conjecture. And then we're supposed to make a conjecture that the mother lode and those things mean that there's some secret agreement. There's no evidence of that. Referring to CBB as the mother lode isn't any different than Mike Smith saying we increased our sales 428% over last year. That's what was in the March 2007 letter. Operation Zero was referred to in the brief. That was about getting consents in for the 2007 amendment to the operating agreement. And merely because Siskey uses some term called Operation Zero is no proof of any conspiracy. Counsel referred to tax planning documents. The undisputed evidence is that Mike Smith had no participation in them. He didn't even know they existed until this lawsuit was filed. And the mere fact that two words, Red Bull, appear on some communication between Rick Siskey and Al Longton doesn't provide substantial evidence of anything. If the question is, were the two words Red Bull disclosed to shareholders? They were. They were disclosed in 2004.
Was Red Bull a customer of CBB at around that time?
No, Red Bull did not become a customer of CBB until 2009. Mike Smith's affidavit tells the long story about how that came about. But these shareholders sell in the fall of 2007 and in early 2008, and Red Bull doesn't even appear as a prospect until December 2008. That's when Red Bull comes over to meet with Carolina Beer and Beverage, and the undisputed evidence is that that prospect started from a fall 2008 Wrexham conference. There's no evidence here of any intent to deceive. Mike Smith constantly touted the financial success of CBB. He did. His letters show that. He consulted company counsel before proceeding. That's the exact opposite of what someone would do if they were intending to deceive an investor. These two facts conclusively show that there were no intent to deceive. And on the point of reasonable diligence, no diligence at all can never constitute reasonable diligence. And this court has consistently held that in fraud claims and in negligent misrepresentation claims, to establish justifiable reliance, a plaintiff is obligated to present evidence that they made a reasonable inquiry into the misrepresentation or that they were denied an opportunity to investigate. We submitted numerous admissions by these plaintiffs that they did nothing to investigate, and none of this information was material anyway, and there is no countervailing evidence. I would point out that the Court of Appeals opinion in Oberlin Capital held that just because when someone had an opportunity to, when there's a representation of an opportunity to review the books, you cannot make an omission-based claim. And as I stated, 5D of every sales agreement represents that the plaintiffs had that opportunity. As to the constructive fraud claim, this court's opinions and the Court of Appeals opinions have been clear. Someone must actually seek an actual benefit and receive an actual benefit for there to be constructive fraud. There were these wild allegations of Super Bowl trips and private planes. None of that ever happened. The counsel points out that Siskey kept detailed, meticulous records, and that Siskey received $22 million from these sales. We showed evidence in the record of payments that Siskey made to the plaintiffs, including Kent Kalina, who financed Siskey's business. There's no evidence of any payments to Mike Smith. He received no benefit at all. The plaintiffs contend that, well, based on this federal criminal case, that there ought to be some presumption of personal benefit when the party is your friend, but that presumption doesn't apply under North Carolina law. The Court of Appeals opinion in Trillium Ridge said you must present evidence of a personal benefit, and this court's opinion in Barger versus McCoy, Hilliard, and Parks held that to avoid summary judgment on a constructive fraud claim, plaintiffs must present evidence showing the defendant sought to benefit themselves, and they had to seek to benefit themselves by something other than continued business relationships and friendships. There's no evidence that Mike Smith received anything in this case. On the Securities Act claims, the statute of limitations for the Securities Act is special, and so you have to look at it there. And that statute clearly places the burden on the plaintiff to present evidence showing that someone concealed the violation or that or prevented the plaintiffs from pursuing the claim. But these plaintiffs didn't offer any evidence of concealment by anybody. They make this argument that it doesn't have to be Mike and Jennifer Smith to conceal, that it's okay if Rick Siskey conceals it. We don't even have to address that argument because they presented no evidence that Rick Siskey concealed anything from these plaintiffs. The plaintiffs simply didn't ask any questions, didn't make any investigation, and didn't exercise any reasonable diligence. On the negligent misrepresentation claim, this court in McGuire versus Lord in 2021 affirmed per curiam the business court opinion, which holds that negligent misrepresentation claims cannot be based on omissions. That's all that was pleaded here. There was no pleaded claim regarding the December 31, 2006 sterling valuation, but as the questions from this court display, the court understands that was a valuation at one point in time, which was shown on these investor statements by a third party. Mike Smith didn't know what was on their statements. And the undisputed evidence is that that valuation was accurate. We submitted expert testimony on that. The plaintiffs submitted nothing in response to that. Although they had a business valuation expert, they did not challenge that opinion. There's also no evidence that Mike Smith provided that estimate in his role as a member or to guide the plaintiffs in any business transaction, and so that they cannot make a negligent misrepresentation claim. As to the conspiracy claim, this court's holdings have said the evidence of a conspiratorial agreement must be more than anything that would create more than a suspicion or conjecture. And that's all we have here. In their opening brief to this court, the plaintiffs simply cited as their evidence of a conspiracy all of their briefs below. That doesn't work. That's not directing the court to anything. And in their reply brief, they cited a single piece of evidence on conspiracy. It's a September 5th, 2008 email, approximately a year after all of these transactions. And all it says is Jennifer Smith, it says, Mike Smith says he's busting his ass on this deal for you. And at the end of it, it has a colon smiley explanation point. This deal was not anything about the plaintiffs. This deal was selling the company. Mike Smith was selling the company at the time. We know that sale process stopped because we all know what happened in 2008. And the sale process did not start again until 2009. The idea and the laws of physics prevented Mike Smith from knowing anything in 2007 about what would happen in 2010, and the company that sold in 2010 was vastly different than the company that these plaintiffs invested in when they sold their shares in 2007. With respect to I'd like to address the statute of limitations generally. Judge Robinson did not rule on that, but I believe it is an alternative basis that you can uphold his decision. The discovery rule is an objective standard as announced by Taylor versus Bank of America. And so when more than 3 years, or whatever the relevant statute of limitations is, has passed, then the plaintiffs have an affirmative burden of showing that they either lacked capacity or they lacked an opportunity to discover the fraud. But the plaintiffs offered no evidence that they lacked capacity or opportunity to discover. Most plaintiffs continued to do business with Siskey. CVB's sale was in the newspaper. All of the plaintiffs also contend that there were immediately discoverable problems. Mallory Johnson testified that the minute she pulled out of her mailbox the packet of materials that was sent by Wishart Norris to her with all of the purchase agreements and the consents, she realized, oh no, this is not the deal I had with Siskey. She had 3 years from that date to bring her lawsuit, and she did not do that. Plaintiffs have offered no evidence that they lack capacity. Plaintiffs offered no evidence that they conducted any diligence. Mike and Jennifer Smith are entitled to finality. We are here 17 and a half years after the fact because plaintiffs never ask questions. We know there are plaintiffs who shredded their documents. This is the whole reason we have statutes of limitations. Blindly trusting Siskey means that Mike was not a fiduciary and that the plaintiffs have no fraud claim. These plaintiffs are trying to disclaim every agreement they sign and every duty they have. Thank you, Your Honor.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. Mike Smith did know about the tax documents. He knew these November 2007 documents existed. He knew that there had been a discussion. Mr. Siskey emails him and says, I'm approaching tax strategy very quietly on your behalf. And those tax documents, everything that's in them turned out to be true. So the idea that a break in time changed things is just not correct in light of those documents. Judge Robinson did not address the question of whether Mike Smith's position as CEO, as an officer, created a fiduciary obligation. My colleague said that the central problem is that Mike Smith couldn't choose between two minority members. He wasn't allowed. Exactly. That's what he did. He did choose between two minority members. He chose Rick Siskey. That was not fair. That's a breach of fiduciary duty. The idea that Gary Smith absolves everything as counsel, when Gary Smith was shown in his deposition the emails between Mike Smith and Rick Siskey, he found them concerning. He didn't know about those. He didn't know the full extent of the sharing of information between these two men. The question of reasonable diligence, yes. Parties do have to pursue reasonable diligence for a fraud claim. For a fiduciary duty claim, you are entitled to trust your fiduciary. That's how fiduciary relationships work. The plaintiffs testified, all of them, that they would not have sold had they known what they know now. That causation exists, and that evidence is in the record for every single plaintiff. And indeed, no reasonable person would have sold. The insider trading letter I want to point to, and I'll end with this. We believe that this action is prudent given the possible liability that may be incurred by many different parties if any more sales of interests occur without all parties having knowledge of all the relevant information.
Thank you, counsel.
Thank you, Your Honor.
Thank you, everyone. Mr. Clerk.